Good evening, and those who have been connected with Beyond Law-CLC would know that Siddharth Sijoria had done one session together with Gautam Bhatia, where he spoke on the basic structure in the Kenyan law. And today, after quite a lot of time, he's connected here with a very interesting facet, Indian jurisprudence in the Commonwealth. And Siddharth Sijoria is a counsel at Clavius Legal, as well as editor-in-chief of the book Indian Constitutional Odyssey, 75 Years of Evolution and Golden Reach. Once he shared this book, I thought, why not have the insights from a person who has considered this spectrum in a larger perspective. And we are thankful that he has accepted our invite. Over to you, Siddharth.
Thank you so much, sir. And thank you for inviting me again for this interesting lecture. And like sir rightly mentioned that if you see in the background, it says Commonwealth Lawyer Association. So I was actually, I'm a member of the Commonwealth Lawyer Association, which is a body that consists of lawyers throughout and across the Commonwealth jurisdictions. And during the year 2024 and 2026, I was also the co-chair of the Young Commonwealth Lawyer Association, which is the body consisting of young lawyers from the jurisdictions. So during my tenure, I knew that as I had studied earlier comparative constitutional law, so I wanted to come up with a publication. I decided, since I was a member of this body, why not come up with a publication or collection of articles where people would share insights into how Indian Constitution has been used, has been referred, cited, distinguished in their countries, so that I can come up with a publication which would showcase that how Indian Constitution has been used across and how Indian Constitution has fared in all these 75 years. So this is how the book looks. I mean, I'll share the details. Sorry, because of the background, I think it cannot be seen, but I'll share uh, share the book with you guys. So when we think of today's topic, Indian jurisprudence in the Commonwealth, what does Commonwealth mean? This would be the first question, Joe, will come to our mind. So Commonwealth basically referred to the crown, which was ruling countries or which was governing countries wherever the British rule was there or imposed. So before independence, every country, and till today, there are several countries in the world which are still governed by the crown. So until 1947, even India was being governed by the crown. India was also the part of the Commonwealth. But after 1947, when India gained its independence from the Commonwealth jurisdiction, there was a demand that India now sever its ties with the Commonwealth completely and become an independent nation who, rather than having the crown as the head of the state, would have a republican form of government, which basically means that we will have an elected leader of the state. So in 1949, there was a London Declaration. And as per the London Declaration, India wanted to establish its severed ties and become a republican form of government and nation. But it also required that in India, it would mean that no more there would be association with the crown, which was opposed because India being such a big country, everybody wanted to have India being a member state. So in this book, one of the Secretary General of the Commonwealth, Mr. Louis Franceschi, has given a very interesting anecdote that how Nehru played an important role in making India a republican form of government and actually leading the way for other colonies to follow, where monarchism would be completely done away with. And in those countries, decolonized countries, it will be a republican form of government. So during that time, Nehru had played an important role in taking this giant leap and making India a republican form of government and creating what is called the Commonwealth of Nations. So you're not a part of the Commonwealth as such, that you are governed by the monarchs, but you have become an republican form of government, which in its history sees that you looks at Commonwealth as a nation or as an organization of which India becomes a part. So until 1947 or 1948, the Privy Council was the final court of appeal for India. And after, in 1949, I guess, the abolition of Privy Council Act was passed by the Parliament, by the Assembly, and because of that, Supreme Court became the final court. So since then, in 1950, Indian Constitution came into existence, and once the Indian Constitution came into existence, therefore the India became a country that led many to join and follow its course. Of course, every country has its margins of appreciation where they would rely or distinguish looking at their own jurisprudence and how India has Indian jurisprudence, particularly if I may say that it is the basic structure doctrine, it is the interpretation of the constitution using the Maneka Gandhi judgment, or it is the freedom of speech jurisprudence in India, which has been widely used across jurisdiction in the Commonwealth, and India has been used as a reference point for distinguishing or giving interpretation to law. So when we think of Commonwealth, we can there are Commonwealth. The Commonwealth still finds itself in the Caribbean nations, in the African region, in Asia. So if we look firstly in the, I would say I would start with Caribbean nations first, because Caribbean constitution has a very interesting aspect that most of the constitution have followed the path which was led by the Indian courts and constitution. Since most of the constitution in the Caribbean region came after India got its independence and had its constitution being framed, therefore, there are a lot of the constitution provisions already contained what Indian constitution provided for in its jurisdiction. If you look at the Caribbean population, 40% of the population in the Trinidad or Guyana region and other parts of the Caribbean contains of population of the Indian descent. Now, I will read certain aspects from the book when it describes what it meant for the constitution in Guyana to mean. So there's a very famous case in Guyana, which is called the Richardson case, where they had adopted the principles of Guyana's constitution from Indian jurisprudence, and so much so that while discussing the aspects of comparative constitutional law in their own jurisdiction, they had quoted Ambedkar widely, and they called that, and it was referred in the book, and I'll read it from there, that there is no more authoritative book as to the approach one should take to those instructions principles as led by Dr. Ambedkar, the venerable scholar and principal author of the India's constitution. So when we look at how Indian constitution was being declared in Caribbean countries, like a lot of the constitution's provisions and jurisprudence is based from India. For example, there is an Eastern Caribbean Supreme Court in the region where in a Nettlefield case, it says that the Constitution of India is fashioned of the Westminster model. Its fundamental human rights provision are para materia with those of Grenada. So when we think of the Caribbean region, when they were implanting the provisions, they were looked at a provision, when they were looking at the provisions of the constitution, it was used that India, it was stated in their judgments, it was stated in the constitution that they were using the Indian Constitution as a guiding light to interpret, and the provisions which were there in the Constitution were used to describe what it meant. Now, if we look at the in the earlier part, like I mentioned about the one of the important aspect of Indian Constitution which has traveled to these jurisdiction. One is the basic structure doctrine. So as we all know, that basic structure doctrine basically means that there are implied limitations on the power of amendment of the Constitution. So in India, there was no such limitation on such power of the parliament to amend the constitution. But as we all know that it was created in 1973 by the Supreme Court to say that though parliament has the power to amend the constitution, but it does not have the power to amend its basic features. So this judgment came in 1973, and since then it has been used across different jurisdictions. Now, when we look at the courts in Caribbean, particularly in Belize, Belize is a jurisdiction where it is quite fantastic to note that in Belize they have used this theory a lot. So in 2009, in Belize, they came up with the law where, as per the law, the government acquired the right to take over the land which belonged or which had minerals underneath, and no compensation was being awarded for the same. And the Supreme and the amending act also stated that there will not be any judicial review of the laws as such. So in 2009, when this case came for discussion in the Caribbean court in Belize, the court stated that though they declared the amendment to be unconstitutional for obvious reason that it took away one of the most essential features of the constitution, which is judicial review. And the court, after citing the basic structure theory and the Indian cases, stated that the Westminster model acknowledges the separation of power, and separation of power also puts duty on the court to make reviews of the laws. Now, this was in Belize. Similarly, when we look at other Caribbean jurisdiction, there is the state, and one more aspect which is very interesting. Like in India, it is very much criticized that the basic structure theory was used in the beginning to only strike down offending amendments, but later on it has been questioned that can you actually challenge an executive action on the ground that it is violative of basic structure theory. So in Belize's judgment in 2019, the court came up with a very interesting improvisation of this theory, and they call it that the constitution contains a lot of provisions and the basic structure theory in itself reflects the spirit of the laws, which is the structure of the constitution. And therefore, if we look at the structure of the constitution, we can even strike down the executive actions as violative of basic structure theory. And he called it not just basic structure theory, he called it the basic deep structure theory. So by imposing or supplanting the term deep into it, the court in fact held that there is implied limitation on amendment as well as the actions of the state. Now, another jurisdiction where it was used is Guyana. In Guyana, they also used this theory that somebody had challenged a constitutional amendment that has proscribed that there would be only 2 term limits which will be allowed to a prime minister. So this gentleman goes and challenges it in Guyana on the ground that there is something called popular sovereignty within the constitution of Guyana, which allows the citizen to appoint a person as his leader. And by using this theory, they said that because it is restricting the right of an individual, therefore it is violative of the fundamental right as well as the basic structure of the constitution. That if you if you bring in two terms limit, therefore my right as a citizen will be proscribed. That I will not be able to elect a leader of my choice, which will again be violative of popular sovereignty, which functions as a basic feature. So this was also this amendment was allowed, but they looked at it from another angle. They said that limitations on the they recognize the basic structure theory in principle, but the court was of the view that though it is allowed, but there is no violation of basic structure because the court stated that it does not violate popular sovereignty because an individual will still be allowed to choose the leader. Similarly, basic structure theory has been used in African region. For example, in 2021 in Kenya, for example, the basic structure theory was cited. It was used in a case called David. And I'm not giving you the case names right now because it's because of the spelling that it's very, very difficult to pronounce also, but it's all there in the book. So in Kenya in 2021, they introduced a concept wherein they wanted to revamp the constitution completely. And in Kenya, the constitution provided that public participation is the key for introducing an amendment. And this amendment was being used without a particular provision of the constitution being followed, which made sure that people are being consulted. So, because consultation was not made, the court thereafter read the basic structure theory, the Keshan case, the Minerva Mineral case, and other cases to come to the conclusion that public participation in view of the constitutional provision is the basic feature of the Kenyan constitution, and therefore it cannot be used, it cannot be violated. Therefore, the whole amendment that brought in the new revamp the constitutional structure was struck down. Now, there is an interesting take on the basic structure theory in Lesotho. So, I've written this in my article about how, in many post colonial constitutionalism, Indian jurisprudence concerning basic structure is used to imply limitation on the amendment, and at the same time the Privy Council and other Commonwealth constitutionalism is being used to define what it means. For example, in Lesotho is also a small country in Africa. There they introduced an amendment to the constitution, and as per that amendment, the constitution provided that if you so the constitution provided that if the prime minister fails to gather the majority and he fails to prove his majority on the floor, he will have to resign, but he will not be able to advise to the king the dissolution of the parliament so that it can go for re-election. So what happened? This amendment was challenged because there was another layer to this amendment that first of all you have to prove your majority. If by simple majority you are defeated, gone. And second limb, that in order to advise the king for dissolution, you have to provide 2/3 of majority should be supporting that motion. So this amendment was in itself so bad that the court said, look, there is an inherent discrepancy in the law. Because A, on the one side, the prime minister fails to gather one simple majority in the house. And then the natural course should be dissolution of the government and the parliament and order re-election. But what you do is you put 2/3 of majority the prime minister should get in order to advise dissolution, which is impossible to do, because if he was able to secure that amount of numbers, then he could have easily secured his majority and confidence in the House. Therefore, the court said this amendment, in effect, what it does, it allows the parliament to function despite the prime minister having lost the uh, the confidence in the House. Therefore, the court called that it is a responsible form of the government is a basic feature of the Lesotho constitution, which means that in case you lose your numbers, you have to advise for the king for dissolution. But because in this case, you cannot do it until you get two-thirds of majority. Therefore, after citing basic structure and the essential meaning of the responsible form of government as derived from other Commonwealth jurisdiction, the court struck down this amendment as offending the basic structure theory and the constitution and the supremacy of the constitution of the Lesotho's constitution. So this was the adoption in the Commonwealth region. Of course, like Singapore and recently Uganda and Sri Lanka has actually stated that there cannot be any implied limitation on the amendment of the constitution. Now, this was the adoption and rejection of the basic structure theory in the Commonwealth region. And now, I'll give you another example of a very interesting nation before I move on to the rights and human rights issue. Like, for example, in Ghana. So, Ghana's constitution was made in 1969, and again, it was revamped in 2010. So, what happens in Ghana is very interesting that in most of the countries, it was stated that judicial, they in their constitution, like most of the post-colonial constitution did not say in their constitution that judicial review is a part of the judiciary, because our constitution mainly emanates from the British constitutionalism, which until very recently did not have a Supreme Court until 2013, and it still does not have a written constitution. So in England, the judiciary does not enjoy the right as we have it in India and other countries. In UK, the Supreme Court cannot say that a law is invalid or it is unconstitutional because A, they don't have a constitution. But what they have is something called the Human Rights Acts of 1998, which provides under Section 4 something called incompatibility. So the judiciary, if any action is done or any law is challenged, the judiciary can only declare the law to be incompatible to the Human Rights Act, but there is no such right vested in the or the authority vested in the judiciary to declare a law to be invalid. So most of the post-colonial constitution, while they were adopting, while they were making their own constitution, they did not provide specifically for a judicial review because mostly it emanated from the British colonialism and constitutionalism, which did not have specified judiciary to overrule a legislative act. So in Ghana, Justice Nene, who has written a piece, he quotes that while the constitution formation was being discussed, Indian constitution, and particularly the Constituent Assembly member, Krishna Krishnavali Iyer was being followed and was being discussed in the constitutional debates to say that judiciary should be given specific powers. So, amongst other things, Ghana has a very interesting aspect. Even it has rejected the basic structure theory, but Ghana has a very interesting aspect, which is a point of departure from India, but quite interesting. So, in Ghana, as we have it in India, that in India we have something called the Directive Principles of State Policy, which is also there in the Ghanaian constitution. But unlike in India, where DSPS are not enforceable, in Ghana, it is surprising that directive principles of state policy are very much enforceable. So what happened that there was a case where the one person has asked that there should be equal distribution of resources, and one person had challenged a particular law for enforcement of his fundamental right, and he also stated that my right also flows from the directive principles of state policy. So what the court did there, the court looked into the constitution and the state's argument. So in that case, state relied on the Indian constitution a lot, and the state argued that, look, we have a fellow Commonwealth country, the India, where DSPS, the directive principles of state policy, are not enforceable. Therefore, you cannot give any enforcement to a person who's seeking enforcement of his right on the basis of DSPS, which is directive principles of DPSP. So the court rejected that argument and looked into Indian constitution and their constitution to say that in India there is a specific provision that says that these are not enforceable. But in Ghana, it is not like that. In Ghana, because there is specific omission to make such a thing or to make it not, there is nothing in the constitution that prevents the court from enforcing it. Therefore, it allowed the enforcement of the directive principles as well. Now, one of the most important thing that has traveled across many jurisdictions is, like, when I was referring to the basic structure theory, I was referring to a very another interesting jurisdiction, which is of uh, the Belize. Belize is very important for two reasons. Belize follows basic structure, and Belize completely follows something which is very rare, and that is the rarest of the rare theory in death penalty cases. So, as we all know, that in India, death penalty was mandatory until some time, and then it was in Bachchan Singh case when its constitutionality was challenged. Then it was stated that death penalty should be given in rarest of the rare cases. Now, it's a separate issue. What is meaning of rarest of the rare? But Belize, because in most of the Caribbean countries, they provide that death penalty is mandatory. Therefore, there is no scope of life imprisonment. And it was mandatorily being given and awarded to prisoners. But in Belize, after referring to Bachchan Singh case and other cases, they decided to. There was this Rees case from Belize where they said that death penalty should not be awarded because it is, uh, mandatorily, and therefore they use the Bachchan Singh principle to say that death penalty should only be awarded in rarest of the rare cases. Similarly, there's another country in the Caribbean region, which is Saint Lucia, which also, using on the similar lines, declared that basic structure, mandatory death penalty should not be awarded, and death penalty should only be awarded in rarest of the rare cases. Now, when it comes to interpretation of the Constitution, Indian Constitution has been a big guiding light in most of these jurisdictions for many reasons. And one of the important reasons for the one of the very important and basic reason is this, that Indian Constitution, when it was formed, we had something called the abuse of the, like in Article 21, which states that the right to personal liberty is subject to the procedure established by law. So as early as the 1950s, only law, and there was nothing like the quality of law that was being discussed at the relevant time. So even in the A.K. Gopalan case, when it was stated that a law should have a quality, that it should not mean that any law which is passed by the parliament should be upheld because it's a restriction on your freedom and your personal liberty. the court stated that if it is law, then it has to be upheld. But later on, in Maneka Gandhi case, it was stated that there should be some quality and life in the law. And law is a golden triangle of equality, liberty, and right to life. Therefore, you should be allowed to and law should not be mere law, and it should carry it the majesty, but it has to be fair, reasonable, and non-arbitrary. So this is how Indian Constitution evolved until Maneka Gandhi came in 1970s. Therefore, this jurisprudence has led and paved way for many constitutions of the world to interpret what it means to be to interpret the laws. For example, in the Kenyan case, there was this very famous case of ALI versus AG, where they discuss what is the meaning of fair, just, and reasonable limitation to invalidate a law that criminalizes defying public officer. So in ALI versus AG, it was a very interesting case because in this case, a person went on Twitter and he wrote that the then incumbent president is stupid and not fit for the job. So when he stated so, then in that circumstance, there was this in that case, the court said that this is a law that provides for defying of public officer is violation of fundamental right to speech, and they said that this law is so broad and so huge, and this law is so you know overbroad that it can bring in any kind of criticism to be it can bring in any kind of criticism to be violation of your fundamental right. So therefore, the court struck it down that defying of public officer is not violative of is not something that is in terms with the constitution. Therefore, it was struck down, and the court reasoning went on to borrow from Indian jurisprudence, particularly the case of Maneka Gandhi, where the court, and I'll read, it stated that free speech means open discussion, and citizen must be entitled to democratic process in order to make intelligent exercise of his right of making choice, free and general discussion on public matters. So they use Maneka Gandhi that any law that violates your freedom and freedom of speech should be struck down. Similarly, there was another interesting case in Kenya where it was similar to the Olega Teles case, where they used the case was called the Mitu Meli case, where certain person who occupied the where certain person who were living on the streets were removed from their houses, and they were asked to leave without relocation, and they challenged it in the ground that look, this is invalid because they had to relocate us and they should not have just moved us across without giving us proper notice. And it is very interesting case because in addition to using the Maneka Gandhi case, the court also used the Vishaka guidelines case to say that in India there was the Vishaka guidelines case which provided for in Vishaka guidelines case, the court provided that in absence of a domestic legislation, the court can also use international instrument in order to interpret the constitution. So what had happened in the case in Mitu, the court stated that look, though there is no domestic law that provides for how to deal with eviction of public at large who are living in a particular area, but there is international conventions, there is international bodies. I'll just read what the so the court stated that house demolition without relocation of people and society first of all, people are entitled to compensation and relocation, and they should be relocated to a place where they have access to education, water, health, and petition. And the government also stated that there was no proof given that notices were served to the persons who were living there. Though there was a proof that remand notice was given to vacate the premises in 7 days, but there was nothing provided which stated that they should be that a notice was given to them. So, looking at this, we can say that Indian, particularly Menaka Gandhi, has traveled a lot within the Kenyan jurisdiction. Now, coming back to again Caribbean jurisdiction, there are two, like it has been used in, like I told you about the case of uh, mandatory death penalty and other cases that I discussed. And secondly, there was a very interesting case from there are two other like in just before I go ahead, I'll also like to refer to another interesting case that I referred to in my writing, is the case in which there's a very famous case of the Indian Supreme Court, where Indian Supreme Court in P. Ratiram stated that attempt to suicide should not be criminalized because it is violative of so many aspects of a human being under Article 21, which includes, you need a medical treatment. So if somebody commits suicide, they don't need to be penalized, but they need to be taken and to care. So, using that case of P. Ratiram, there is a very interesting discussion in the Kenya Constitutional Court where, at length, they have discussed about person should be, they struck down their provision which criminalized attempt to suicide, but at the same time, it also allowed that care must be given. So, using again Maneka Gandhi, they upheld they struck down the law of attempt to commit suicide. Now, there's another case that I wanted to refer to. So there is like I mentioned to you earlier, like this is very interesting. Like I referred to you that in India, in Article 13, we have something in Article 13, we have something called the laws which are made uh, uh, and which are inconsistent with Part 3 of the Indian Constitution are void. In many of the Caribbean jurisprudence, this word is absent, that the laws are not declared to be void. So the question arose that even after getting independence, the laws still had the presumption of constitutionality. And even if they were void of the Part 3, they were not being declared so because no such provision existed in the Constitution. So in there's another court in the Caribbean. It's called the Eastern Caribbean Supreme Court, where they cited D.D. Basu's book, Sirvai book, and to say that, first of all, to say that if there is a presumption of constitutionality, the burden of proving it will always lie on the person who alleges. And also using this, they stated in their judgment one judgment from a country called Dominica, which is there in the Caribbean, and the judgment was of cables and wireless, where they used the Indian Supreme Court to say that, look, when you have a judicial power to invalidate something which is violative of human rights and Part 3 of the Indian Constitution, if Indian Constitution gives judicial power to strike down a law which is unconstitutional because it is violative of fundamental right. Therefore, citing the Indian cases, despite there existed no specific express provision in the Constitution, they cited Indian court to say and state that, look, even despite the fact that there is nothing in the Constitution of the Caribbean constitutions like the countries that are referred to, they still had the right to strike down the offending amendments. Indian cases with respect to uh, Indian cases have been referred a lot. Recently in the CCJ. CCJ stands for the Caribbean Court of Justice, where they have used the judgment from Navtej Johar case for upholding equality rights in upholding the rights of the person in terms of their sexual orientation, and judgments have been used to uphold privacy of an individual. So there have been cases like this across these jurisdictions where we can see that Indian constitution cases have been referred to at large, and I will also like to refer to a very interesting aspect of free speech, like in Malaysia. So I've always seen, like in Malaysia, people are on the street asking for uphold of their free speech. And Malaysia is the country where you will always find a lot of protest taking place. In Malaysia, as opposed to India, Malaysian constitution provides that whenever a person is convicted, then in India there's a test of mens rea, that you have to prove mens rea in cases of sedition and other cases, or for defamation, that you intended to cause that harm to the reputation, or other cases where free speech is a part. But in Malaysia, the test is of strict liability. So, notwithstanding whether the standard of proof is such that notwithstanding the intention to cause, they always uphold it on the ground that if that result or the consequence has taken place, therefore there is no need to go into mens rea, but only on the doctrine of strict liability, a person can be prosecuted and convicted. And similarly, there is no test of reasonability that exists. Like in Article 19.2, what we have is a reasonable restriction. There they only call, which is the last limb of a constitutional test, which is the necessity test. So they don't look whether it is whether it is a test which is they don't look at whether it is reasonable restriction in terms of proportionality to the right, but they only look whether it is necessary. So the necessity doctrine gives a lot of weight to the state to control your free speech. So I think what it all entails is that Indian jurisprudence has enriched itself in past 75 years, and Indian constitution has seen a strong fight for supremacy when it was in Keshanan Bharati case, when Indian Supreme Court in 1950 till 1980, the journey from the procedure established by law until the due process of law was formed in Maneka Gandhi, has actually developed and enriched its jurisprudence in such a way that India has been understood to, or Indian Supreme Court jurisprudence has become so important that it has led many countries to look at our constitution, our interpretive techniques, in order to give life to the spirit of law and the meaning of the text in the constitution. And if you ask me, that I have been very impressed with the way Indian jurisprudence has been adopted in the Caribbean countries, because in because it mostly is the English speaking countries, and Indian jurisprudence has been completely, or Indian jurisprudence is totally used. I was surprised to see that they have come up with the basic deep structure theory. So it's very interesting, and I think in this book, Indian Constitutional Odyssey, 75 years of evolution and its global reach. If we read, there are about 35 articles about evolution, the changes, and its transportation to different countries, where each judge and the lawyer and the jurists who have written for the book, they have referred to so many Indian cases being discussed and distinguished and cited in their countries. So I think Indian jurisprudence is something which has traveled across countries, particularly in the Commonwealth, and it has been mostly used, and it has actually paved way for many countries in order to make their own constitutional structure. So I think this was my time, sir. I think if anybody has any questions. Sir, it's a
Yeah, I'm just checking it out as to whether we have any questions.
such a
It says, what does the phrase Indian jurisprudence and Commonwealth mean in today's constitutional landscape?
sorry, sir.
What does the phrase Indian jurisprudence and the Commonwealth mean in the Indian constitutional landscape?
So even in India, for example, like whenever we are referring, like if we look at the cases with respect to Article 19, so there is a very famous case of R versus Oakes from Canada. So that was the first case which was used to discuss in depth about the proportionality test, and it has been referred to while discussing the limits on freedom. And many other cases, in the constitutional cases, they have referred to the Kenyan jurisprudence in terms of what it in interpretation of fundamental rights. So even Indian Supreme Court uses many of the jurisprudence cases. For example, we all have seen the All England reports, which brings in cases from different parts of the uh, Commonwealth and Privy Councils being reported there. So even while in India, Commonwealth jurisprudence is being used to as a persuasive tool in many other cases.
Yeah, this is which constitutional judgment you feel that a young lawyer should read and understand?
I would say that if you are looking at the Constitution, one judgment is of course Keshandan Bharati case, which is very important to understand the Constitution, not just because it talks about amendment power, but it talks about everything about Constitution. जैसे सर in this case अपना मेनका गांधी का जो केस है, if we look at that case in Menaka Gandhi, it's a beautiful piece of judgment because it is actually changed from a it was a constitutional leap from understanding of the constitutional principles. जैसे Menaka Gandhi case is most important to understand that what it means in a country where only law is to be seen and what is the quality of law has to be seen. So as it is stated in many, as it is stated, there's a very एक बड़ी अच्छी book है sir. I it's called the legal something, I can't remember the name. I'll share it with you. But it says very important thing that law in itself, you cannot call law as justice. For law to be justice, it has to have certain qualities. And one of the qualities is what Menaka Gandhi discussed, that it should be fair, reasonable, and non-discriminatory. And I think constitution, sir, should be, I think every judgment becomes very relevant. But as a student of constitution, as a practitioner also, I feel constitution should be looked as a science. It's not a document on which one can have opinion because everything has a scientific way of solving issues. For example, if we are talking about Article 21, then we talk about restriction in terms of Menaka Gandhi. And then we have something called restriction on your freedom. Then we have something called the proportionality test. Then we have equality. Then we have something called the intelligible differentia case and other cases. So I think constitutional cases should be read because it has so much of relevance as a scientific tool to interpret individual rights.
So thank you, Siddharth, for sharing your knowledge. We will stay connected. Thank you, everyone.
Thank you so much, sir. And I think I'll share the book with you, sir.
Yeah.